नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Now read along with that your next provision, section 232. Performance of contract with agent supposed to be principal. Where one person, it may appear to you that I am reading. Definitely I am reading, but I am reading the bare provisions because again focus on that. What is required for this topic? Interpretation of bare language. For that we are bound to read the provision as it is, first of all, from your bare act. Performance of contract with agent supposed to be principal, where one man makes a contract with another, neither knowing or having reasonable ground to suspect that other is an agent. The other is an agent. The principal, if he requires the performance of contract, can only obtain such performance subject to the right and obligation subsisting between the agent and the other party to contract. So in your section 231, we gave a right to the principal, we gave a discretion to the principal who is undisclosed one, that he can have the performance of contract. But at same time, section 232 is here laying down a principle that such undisclosed principle can have the performance of contract against the third party, but he will get the performance subject to the contract between the third party and his agent without affecting their mutual rights and liabilities as a party to contract. तो पहले मैंने आपको बोला ना कि थर्ड पार्टी will be bound to perform the contract. There is no doubt. This is because discretion of the undisclosed principle. लेकिन at same time I told you, according to section 231, third party क्या कर सकती है? Can treat the agent as a principal for the contract between them. मतलब same rights, same liabilities they may exercise. फिर उसी चीज को reinforce किया है your section 232, which is saying कि undisclosed principal will have the performance, but he will take the performance subject to the rights and obligation subsisting between the agent and the third party. So this is one thing. So after that, let us talk about, this is all about the agency scope relating to what? Relating to undisclosed principle. So if somewhere, let me tell you, somewhere the principal has not disclosed the name of the principal. Agent has not disclosed the name of the principal or the existence of the principal, and he has not even disclosed his representative character. Please listen carefully even if you are not listening. If somewhere agent did not disclose the existence of principal, if somewhere the agent did not disclose the representative character of him, then there will be no liability of third party towards the undisclosed principle unless and until undisclosed principle is interested to have the enforcement. तो undisclosed principle enforcement तो करवा सकता है, but it will be always subject to the rights and duties between the third party and the agent. Is it clear? So with this now we are talking about where there will be the personal liability of an agent. Answer me, whether in a contract of agency, as per you, do you think so there is any personal liability? Okay, for that I want to tell you there is a provision in your agency chapter which is talking about personal liability of agent, and that section is section 230. Section 230. Read your section 230 from your bare act. Agent cannot personally enforce nor be bound on behalf of the principal. So on the very first hand, it is clear from the heading to you, heading of your section 230 to you, that an agent will never be personally liable. So first principle, general principle is what? Agent will never personally liable, will never personally bound with the contract which he entered on behalf of the principal. There is no liability, right? As we have already done, that principal will always be liable for any kind of the act done by the agent within the scope of his authority. But further, section 230 itself is giving exception to it. For that, we need to read your entire provision. So read your section 230 in absence of any contract to that effect. So please mark this phrase. First of all, section 230, which is dealing with the personal liability of the agent, is having a scope for agreeing by mutual consent something contrary to the basic principle that agent can never be personally liable. So principal and agent can agree for the personal liability of agent. So read, in absence of any contract to that effect, an agent cannot personally enforce contract entered into by him on his behalf of his principal, nor is personally bound with them. So it is clear, it is just giving you the principle. Another thing itself, your section 230 is providing the three situations where there will be always a presumption that agent will be personally liable. What are those three situations? Such a contract shall be presumed to be exist. जो हमने ऊपर बोला ना, something contrary can be agreed. Principle is what? Agent will never be liable. Basic law is what? Agent will never be liable for his any act. This is the principle who will be liable. But at same time, section 230, which is giving a saving clause that unless and until something contrary has been agreed between the party. तो उसी phrase के लिए that unless and until something contrary has been agreed, there is a presumption. There is a presumption, and what is that presumption? In three circumstances, section 230 is saying that whether this will be agreed or not, it will be presumed that a contract has been agreed for the personal liability of agent. What are those three situations? Where the contract is made by agent for sale or purchase of goods for a merchant resident abroad. So it is very simple that if somewhere there is a contract of agency for the sales of goods on behalf of the principal by the agent, then in such a situation we need to add on one more fact that if in such situation the principal is a person who is living in foreign, who is living in abroad, who is a foreign merchant or who is a merchant resident of abroad. So agar suppose I'm just giving an example that if I'm living in America, you are living in India, I appointed you as my agent for selling of my certain goods, right? So उस situation में, even though you are just an agent, and as per your agency law, general principle that there will be no liability of the personal liability of agent, but in this situation, as an exception, where I am living in abroad, you will be liable for personally. You will be also personally liable for any kind of act. Is it clear? So this is first exception, and I just want to tell you that this is based upon English doctrine. First of all, it was followed in England. This presumption was followed in England, and we incorporated it in your provision as a rule of law. Then thereafter, second situation which is given by your section 230, that where the agent does not disclose the name of his principal. If somewhere, let me tell you, the second situation where the agent will be personally liable, which I just explained you earlier, where agent do not disclose the existence of the principal, where the agent do not name the principal, then in such situation there will be liability of the agent. What liability? personal liability. So this presumption as per your section 30 will be there if somewhere the agent do not disclose the name of the principal, he will be personally liable for it. Third situation, where there is existence of the principal but principal is now either not in existence or principal is incompetent. For example, I'm your principal, right? And I appointed you as my agent, and later on, I turned to be unsound mind, right? Or if at the time of a contract I'm minor, then in such situation there will be personal liability of agent. So, or if I after making the contract of agency with you, I died. So in that situation, the principal is not in existence or principal is otherwise not in competent or principal is incompetent, then there will be liability of agent, and this liability will be personal liability as an exception recognized under your section 230. So let me just wind up. Section 230 is just telling you that a principal, an agent will never be personally liable for any act. This is the principal who will be liable. But in these three situations, agent will also be liable. First situation is where it is an agency for sale of any good and the principal is living in abroad. Second is where the principal is unnamed, means agent did not disclose the principal. So there will be also personal liability of agent. Third is where the principal is not in existence anymore or principal is incompetent. Then there will be liability of the agent, and it will be what? It will be the personal liability of agent. Now, let us again talk about a situation where the principal is unnamed, where the principal is undisclosed. Then what will be the option available to the third person? Listen carefully. What will be the right of an unnamed or undisclosed principal that I have explained to you earlier by referring your section 231, by referring your section 232. Let me just wind up and let me just start the third party's right or the option available to the third party in such situation. Please listen carefully about whom we are talking. Undisclosed principal, right? अब अनडिस्क्लोज प्रिंसिपल में एक्चुअली अफेक्ट कौन हो रहा है? इफ अ सिचुएशन इज सच दैट प्रिंसिपल इज नॉट डिस्क्लोज, two people are getting affected. One, who is the principal itself, who is undisclosed. Second is the third party who is in misconception that agent is the principal. तो पहले जहाँ तक for the right of undisclosed principal is concerned, by making reference to your section 231 and section 232, we have learned that undisclosed principal can have the performance of contract, but it will be subject to the rights and liabilities of arising under a contract between the agent and the third party. तो उसको तो हमने enforcement right दे दिया, discretion दे दी. If he is interested, he may. If he is not, then he may not. Now, what is the right or what is the option available to a third person? Then third person will be entitled. Third person will be entitled to have the enforcement of the contract against the agent as a principal, means as actually the contract थर्ड पर्सन और एजेंट के बीच में हुआ है. सो ही विल एक्सरसाइज एवरी राइट, और इन अदर टर्म्स देयर विल बी प्रिविटी ऑफ कॉन्ट्रैक्ट बिटवीन द एजेंट एंड द प्रिंसिपल. सेम राइट, सारे ऑब्लिगेशन. अदरवाइज क्या होता है, एजेंट को कभी आप स्यू नहीं कर सकते, एजेंट परफॉर्मेंस ऑफ कॉन्ट्रैक्ट के लिए लायबल नहीं होता. लेकिन अगर ऐसी सिचुएशन होगी जिसमें अनडिस्क्लोज प्रिंसिपल है, तो थर्ड पार्टी can make the agent liable. Third party can ask for the performance of contract through the agent. On one more thing, third party सिर्फ agent को liable नहीं कर सकती. Third party can liable to the undisclosed principal as well. So the next step which we are going to learn, if in a given situation, listen carefully this, if in a given situation a third party is having a right to make liable both principal as an agent. Either it is due to the exception under section 230, right, or otherwise it is agreed between the parties. तो ऐसी सिचुएशन जहाँ पे थर्ड पार्टी के पास राइट है to make the principal as well as agent liable for the performance of contract, then what kind of option will be available to him, how he will exercise his right, that has been given under your section 233. Please see your section 233. Then I will take your question, Isha. See your section 233. Right of person dealing with agent personally liable. Right of person dealing with agent personally liable. In cases where the agent is personally liable, a person dealing with him may hold either him or his principal or both of them liable. So, just right now, we did your section 230. And your section 230, we learned 3 exceptions where there is personal liability of agent. ठीक है? Personal liability of agent कौन-कौन से केस में where you have it is a sale of contract for sales of goods and the principal is living in foreign. Second, where the principal is unnamed. Third, where the principal is non-existence of principal or incompetency of the principal. So situation is section 233 is saying the third party can either make principal liable only, can either make agent liable only directly or can make both of them liable. Right? मतलब वो दोनों के अगेंस्ट सूट फाइल कर सकता है. But here, I just want to tell you, the law in England is different on that point. In the similar situation, the law of England is different. What it is, where the third party has to elect, means here we are giving election option to the third party. Na? He can make either principal directly liable, he can either make agent directly liable, or he is having power to make both of them liable. He can file suit against both of them. But in England, he has to elect. He has to elect whether he wants to make principal liable or whether he wants to make agent liable. He can make only one person liable, right? He can make only one person liable. He cannot make both of them liable. But there is a wider scope situation, wider provision or wider relief available in India under your section 233 that third person can make both of them liable. He is not here required to elect. Right? He is not here required to elect. So, before moving further, Isha, I want to take your question. Ma'am, if agent is not disclosing the name but disclosing that he is acting on behalf of someone, is it so that agent personally liable under section 230? Yes. Isha, please mark my words. I use the term unnamed principal. ठीक है? Unnamed principal is covering both situations where he is disclosing the name, where he is hiding the name only, or where he is hiding the name and representation both. Right? So, next thing, which point I just explained you in regard of the third party, is that clear? Is there any question relating to it? Liability of the third person? Right of a third person in regard of making liable personally, principal, agent or both of them where there is a situation of undisclosed or unnamed principal. Is that clear? Please message me. Tell me whether your section... Okay, section 233 is clear. Thereafter, estoppel of a third person. इसी के extended में section 233 is not to be read alone. Section 233 is always to be read with your section 234. So once you you said to the principal that okay, I will make only agent liable, or you assured the agent I will only make the principal liable. Later on, you cannot step back. Listen carefully. First of all, I am just explaining you in a very simple language. If somewhere in any contract of agency where the agent has not disclosed the principal name, then the third person, if if the third person has once assured the principal that I'm not going to make you liable, or he has made assured the agent that I'm not going to make you liable, instead of that I will file a suit against the principal, then in such situation there will be doctrine of or the rule of estoppel application, and later on he cannot make such person liable for whom he has given exemption earlier. So read your section 234. Consequences of inducing agent or principal to act on belief that principal or agent will be held exclusively liable. So read the provision where a person who has made a contract with an agent induces the agent to act upon the belief that principal only will be held liable, or induces the principal to act on the belief that agent only will be held liable, he cannot afterwards hold liable the agent or principal respectively. So once you have induced the principal to act in the same contract, or once you have induced the agent to act in the same contract, later on you cannot step back and you cannot make them liable respectively. Is it clear? So this is what your section 234. This is what the law relating to undisclosed principle. Now let us talk about the fourth possible situation in the same contest, that is pretended agent. Pretended agent. For the pretended agent, we will read your section 235. Pretended agent. What is your section 235? And as per you, what do you understand by the pretended agent? Means who pretend himself to be the agent, who is actually not agent, who pretend himself to be agent of some person to a third party. So first of all, read the provision, then we will learn that what will be liability of a pretended agent. Pretended agent means who is actually not an agent, who has not got any authority from the principal, but who pretend himself to be the agent of a person to the third person. What will be his liability? So liability of pretended agent: a person untruly representing himself to be the authorized agent of another. A person untruly representing himself to be the authorized agent of another, and thereby inducing a third person to deal with him as agent, is liable if his alleged employer does not ratify his act to make compensation to other in respect of any loss or damage which he has incurred so dealing. So it is quite simple. Suppose I have not appointed you as my agent. You started to pretend yourself, or you started to represent yourself to be as my agent to a person, third person, XYZ. So situation में क्या होगा? I will, unless and until I will not ratify your act, unless and until I will not by ratification I will give you the authority, you yourself will be personally liable for that. And let me tell you, in such situation, the liability will not be only under your section 235 of Indian Contract Act. Simultaneously, there will be liability under your tort as well. Means you will be liable under tort, right? And in regard of your same section, same concept, we will read your section 236 as well. Section 236, who is here dealing with the pretended agent. Read it: person falsely contracting as agent, not entitled to performance. Right? Means what? You were not my agent. You falsely represented yourself to be as my agent, and later on I did not ratify your act. अब आपने तो कॉन्ट्रैक्ट थर्ड पर्सन के साथ कर रखा है. अब चाहे आपका कॉन्ट्रैक्ट थर्ड पर्सन के साथ है, बट इवन दो you will not be entitled to have the enforcement, because it is written in your section 236, person falsely contracting as an agent, not entitled for the performance. Now read the provision. A person with whom a contract has been entered into, the character of agent is not entitled to require the performance of it if he is in reality acting not on his agent but on his own account. So thereafter, for today, the last the aspect which I want to discuss in regard of the scope of authority, that is a breach of warranty. Breach of warranty. What we understand by breach of warranty means somewhere that there is any agent who did any breach of warranty of authority. Means an agent is bound to act only within the scope of authority. And if somewhere he is acting out of the scope of authority, in legal terms it used to be considered as breach of warranty of authority. Breach of warranty of an authority. So where a person who is an agent but exceed his authority to represent someone, then there will be personal liability of agent for that, and not more than, and the principal will not have any liability therefore. So with this, we have completed all about the scope of authority or possible situations that where the agent do not disclose the name of the agent. Then what will be the situation in those possible situations? What will be the law in those possible situations, or how to deal with, how to govern the rights and liabilities. So in your next class, I am ensuring you it won't take more than 20 minutes to explain the two remaining aspects, that is ratification and termination of agency. Ratification and termination of agency. And in your next class means in next week we will start the partnership. Is there any doubt for today?
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें, ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं, जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।